there and taps his hands, and you're just sitting there, and he, you know, sits there and rocks back and forth in the chair, sitting there big old another murderer or whatever he is, convicted, up to this point of a case, not in handcuffs, not in shackles, one or the other, or both, and in orange.
Hello, can you hear me? Hello, can people hear me okay? Hi. I don't know. I'm just trying to see. You can hear me now? Oh, yay. All right, just a second. My connector thing, see this? It's summer here in Australia and it's overheating. This thing, it blew up. I'm not kidding. Yeah. I'm all good. All right, hang on. I just need to see that I can. Am I echoing at all or anything like that? Because I'm not sure whether or not my earbuds are working. Let me just check that. Have I got an echo? I'm all good. All right. When I start audio, I'm not sure whether that's going to work or not. My whole life, well, I do have a spare one, right? So I've just gone into the other room, grabbed a spare one, and replaced it because I was like, why? This has been happening the last few days. Why has my internet just been coming in and out? And I just realized, like, I went down to touch it and it was like burning. I was like, oh, right, okay, that would make sense. Yep. Okay. All right. I still don't know whether or not my earbuds are working or not, but if they're not, I will just change over to my headphones. That's fine. Thank you guys. Thank you for hanging about whilst that weirdness happened. I'm so sorry. Because I have a Mac, yes, and the Mac does not have an Ethernet port. So yeah, I need to swap between USB-C and Ethernet. So see what it does. You did get to see the beginning part though, right? You got to see the pretty video. I thought, okay, well, my internet crapped out. I was like, oh, at least the video goes for a minute and a half. You were worried? Do you think I got like sucked into an internet void? Yeah, nah, it's just it's the Australia vortex thing. It does suck. You didn't get to see the video? Really? Did it stop halfway through? That's sad. Thanks. No thanks. Dali, who was backstage checking what was going on, reassuring chat. Were you reassuring chat, were you? Oh, that's nice. You did see the video. Oh, good. All right, sweet. Thank you all my loyal friends here who are nice and hanging out, wanting to check I'm all right. I can't believe that was all that was. I'm so pleased I worked out what was wrong, though. I'm so pleased I worked out what was wrong because I was like, how am I going to fix this? I got my third, fourth internet issue in the last few months. Let's get into it, guys. You feared a copper was standing at your door saying, do you got a license for that internet streaming thing? Oi, oi, we'll call the Prime Minister. Thank you for helping, Dali. Oh, yeah, much appreciated. Okay, let's get into it, guys. Let's get into it. So today is a Kohberger stream. It's my favorite topic, my favorite case, the one that I am most familiar with. Aside from the Zachariah Anderson case, which is the one closest to my heart. I love the Andersons. I'd do anything for them. But the Kohberger case is one that really worries me. It worries me because I think they have the wrong guy. I'm pretty sure they have the wrong guy, unless some sort of bombshell evidence comes out that surprises me. I think they have the wrong guy. And since the trial has moved to Ada County in Idaho, we have a new judge. For your crappy internet connection fund, $2. Thanks, Ilya. That's gonna fix it. That'll fix it. I appreciate the super chat though, and just for you being a great friend and popping back here and trying to help. You're a sweetheart. That'll fix it. You know, $2 US is $20 here. Kohberger to Hella is like Wade to Dali. Yeah, that's what it is. Okay, so I think they've got the wrong guy. And what happened was there was a motion for change of venue, and that was a big deal. It was a big motion, 130 pages or so. There was a lot of research done by a doctor called Dr. Edelman, and when I say doctor, PhD. Dr. Edelman did market research in the area and in the other counties nearby to see how much exposure people had had to the case and how much their views had been tainted by the media and by the PCA, the probable cause affidavit that had been put out in the beginning, to show how much of the incorrect information had filtered into their brains and potentially the juror pool, to show whether or not they could get a impartial jury in Latah County. And it was proven quite clearly that they could not, thank you, Suni, that they could not get a impartial jury in Latah County, much to the victims' families, or the Gonslavis family, to be specific, much to their chagrin. But it got moved to Ada County very quickly. It happened within a week of this Idaho Supreme Court, because it got headed over to the Idaho Supreme Court for them to make the decision. It got handed over to them. They made the call for it to be moved to them. And within about a week of that occurring, not only did Judge, who was the judge at the time, say to the Idaho Supreme Court, hey, you know what? You guys make the call, but also you make the call as to whether or not I will be the judge. So you be the judge as to whether I will be the judge. And you know what? He wrote it in sort of legal terms, but I don't really want to be the judge. In fact, I don't want to be the judge. I'm not going to be the judge. You guys pick a new judge. And since then, he's announced he's going to retire. So there's a new judge, and it's this Hippler guy. And he's a very different judge to Judge John Judge. Yes, the old guy was called Judge John Judge. JJJ. So we have this new judge on board. We have him in. And Sean, thank you for the super sticker. Isn't that nice of you? It's lovely to have you here, Sean, from Sydney. Watch out, Sean. The heat might make your internet or your peripherals explode. That's different for the people in the US who are freezing. How did Hitler become a judge? What timeline is this? Yeah, you gotta be careful how you say it. It's Hippler. 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 Yes. Hey, Lexi, good to see you. The trial is next year. It's set for, I think, the latest date that's been put down is August next year. Someone in chat might correct me on that. I sound really bad for not knowing that, because it was July and then it was September. I think it's August. Anyway, Judge Hippler is a different kind of judge. If everyone remembers Judge, he was kind of this Homer Simpson kind of character who kind of sit there and go, oh, what do you want me to do? Do you want me to sign these papers? Okay. I was a little Spanish bee. And he kind of sit there and just let everyone talk, and I don't know what's going on. Judge Hippler is not like that at all. At all. August doesn't work for me. Can we do December? We can't do that because Bill Thompson's got other things to do in December. Santa's kind of busy around then. Yeah, we can't leave it that late. Yeah. No. So anyway, let's have a little bit of a look at Judge Hippler for a minute, because if anyone recalls what Judge Hippler was like on the very first day that everyone walked into his courtroom in Ada County. And remember, it's 7 hours away, 7 hours drive away from Latah County. So it was a big deal for everyone to pick up and move. Like all of the lawyers, everybody has to now go to Ada County for the hearings. It's okay for Bryan. He got a helicopter and now he's in a different jail. Apparently it's a bit of a better jail. Latah County, we found out since, is dilapidated and needs to be pulled down. So he's not living in a lap of luxury, but I think it's a better jail. Hey, Melissa, how are you? So what I wanted to show you is what a nice guy he was on the day that they all met him. So let's have a look at that. Oh, I have to set my share screen up again because everything died. You know, because I'm always like well prepared, but everything died. So I have to be more prepared. 2 seconds, guys. All right, so now I can share, go. Where is it? Oh, sorry. See, now I'm off my game. Now I'm just off my game. You can all make fun of me for a minute. I'm a big boomer. I've got logos of trucks that might not be logos, they might just be reflections. There we go. All right, now I can bring that in. All right, so this is the first day that they met him, and just check. Okay, and this is what he had to say.
All right. Like to tell you I'm happy to be here, but why start with an untruth? I am accepting of my responsibility to be here. I want to go over with you some expectations of mine, given that I don't.
Did you get that? So I'd like to tell you I'm happy to be here, but why start with an untruth? Yeah. Hey, Diane. Yeah, did you see what happened? This is my connection. It exploded, basically. It was like on fire. So I had to replace it just as soon as my stream started. Fantastic. Yeah. So, yeah, he was just like, I don't want to be here, but I gotta be, so suck it up. And he spent that hearing pretty much throwing shade at everybody. Throwing shade at the defense, throwing shade at the old judge, throwing shade at the Supreme Court, throwing shade at the investigators, at the state, at everybody. Like, he just was a bit of an ass. So, yeah, okay, cool. And he sat there like a bit of a school principal going, everyone's going to get along. I know that you all want to win, but this is not about winning. You need to not get involved in theatrics. You need to not have get involved in ad hominem attacks, all that kind of stuff. You just need to behave yourselves. So sit down and behave yourselves, please, because this is my court. So that was how he set the proceedings up right from the beginning. He was sort of marking his territory, and that's fine. Whatever. If that's how he wanted to be, that's fine. So, David, there you are. You ignore Ilya and watch that video I sent you. Okay, so David, the video you sent me is something to do with what happened at some party, involving the Sigma Chi or something, Sigma Chi or whatever. Okay, so I'll just put this out there right now. And this is nothing against yourself, David. On this channel, and in regards to my coverage of the Kohberger case, there are lots of channels and lots of people that are interested in covering alternate theories of what might have happened with the roommates or the housemates who might be responsible for these murders. And that's fine. That's not really something that floats my boat. I'm not really that interested in alternate possibilities or what else was going on in their lives. Like, that's, I know Diane's interested in that stuff. She watches all that kind of content and knows a lot more. Diane in chat knows a lot more about those things. For me, I'm really interested in anything that comes up that is pertinent to the court proceedings. So I'm interested in what they have on Bryan. I don't think he has anything to do with that fraternity. He's not connected to the housemates. He's just not. So if there is a connection, if there's something in that video that shows a connection between Bryan and them, then let me know and I'll go watch it. But I don't think there is. So therefore, that's not really something that I'm interested in covering on the channel. I want to focus a lot on what they have on Bryan, and I think it's very little. So yeah, there's lots of people covering all that stuff. Okay, so that's where Hippler was at that point in time. Now, that was the introductory of Hippler to the case. Now, he came off kind of not very likable and very businesslike. He actually set a not ex parte, I suppose in a way it's ex parte, a closed hearing just after that very short hearing, in order to hear the defense's concerns about a mitigation expert who had passed away. And the reason why that couldn't be done in the open hearing was because it would give away some strategy. She needed, and Taylor needed some extension to her timeline. And he accommodated that straight after this hearing. Now, I can tell you, Judge would never have done that. He would have waited, and it would have taken extra time. And so people, I suppose, were kind of like, wow, things are happening really fast. But then again, there is this secrecy already being set up. So this continuation of the secrecy is a little bit of a problem. Okay, so I want to go back and look at what Andrea said straight after this hearing, because I like to involve or base my thoughts on people who know more than me, and then carry on with that and go, okay, so this person gives me this information, this person gives me this information, what can I then build on that information with? Because I don't know everything. I'm no expert, but I can utilize all that and learn more, right? We all can. So I had put a link in chat to her Substack. So that was a little bit earlier. And this actually came from the free version of her Substack. If you subscribe to it, you can get that. So I'm going to now share this tab instead. Okay, so just after that hearing, she sent out just a 2-page summary of what she thought of Judge Hippler and a little bit of background on him at that point. And I just took this little part of it. So Judge Hippler has presided over felony criminal cases for about a decade as a judge, and from his appellate record, his decisions do not appear to be controversial. That's important because it means that he doesn't have he hasn't appeared a lot in, he has got a long appellate record, like his name doesn't come up a lot on appeal, right? So not many people have challenged him. Despite being on the bench for more than a decade, few of Judge Hippler's rulings have produced published appellate decisions, and I found only 2 reversals out of more than 100 rulings. Once in a civil matter involving whether a health organization constituted a tax-exempt charity, and once in denying a motion to suppress. Now, isn't that interesting? right? Now, Kohberger people who've been following the docket, a motion to suppress, hey? Who knows what's coming up very soon on the docket? Quite a few motions to suppress, right? So that's why I picked this part out of Andrea's document that she wrote. This is back in September. This is September 30, 2024, and it's called Getting to Know Ada County Judge Stephen Hippler. And I thought that part was interesting because he's been overturned once in denying a motion to suppress. Do you think he particularly wants to be overturned on another motion to suppress, guys? I wonder. I don't think so, but wouldn't that be interesting to have on his record, another overturned motion to suppress? So I think he's going to be a little bit careful when it comes to all these motions to suppress that are coming before him right now. When I'm talking about motions to suppress, I'm talking about these. So if we look on the docket here, we have motions to suppress. Now, here we have these are crucial. What's coming up in the next month or so, and they're due to be argued in January. So January 23rd, 22nd, 23rd, I believe, and it might go over into the 24th if a Frank's hearing happens around then. So if we have a look here, we've got a motion for Frank's hearing, and we'll talk about that a little bit more in a minute. But then we've got motion to suppress genetic info, motion to suppress Amazon, apartment, Apple, arrest warrant, ATT first warrant, cell phone data, Google, pen trap, trace device, person in ID, that's Idaho, person in Pennsylvania, White Hyundai, 119 Lambston statements redacted. So all this here, this is all the defense coming forth saying, we want all of that suppressed, and it's due to warrants being unlawfully obtained. There's some really important stuff in there that is, a lot of it hinges on two things. Firstly, the Elantra, the white Elantra, being dated incorrectly. So in the first instance, the Elantra was put out there as being a model that was 2011 to 2013, I thought. Yeah, I think that's right, 2011 2013. And then they changed the date of it to be a later date, so 2015. He drives a 2015. Correct me if I'm wrong, Kathy. Is it 2015 or 2016? Hey, Kathy, how are you? Yes. So that is one of the crucial problems here. Yeah, it was 2011 to 2013, right? So that was what it was originally. So they're putting forth that the police lied in order to obtain a search warrant, and expanded the date to be a later model. The other problem is that the genealogy search was done unlawfully as well. So they obtained his DNA through an unlawful IgG search. So none of this other stuff would have been able to, none of these other search warrants would have been able to have been gotten unless they had done that unlawful IgG search. So again, wouldn't it be interesting if he now gets a second motion to suppress overturned in an appellate court? He's going to be really careful to not have that on his record, isn't he? I think that's really interesting, that that's the thing that he has on his appellate record in terms of criminal trials, right? So he's going to be watching out. If this happened to your child, would you say it must be the teaching assistant who lives in another state and doesn't know them. Sorry, I'm not following you there. Too much info. What about a defense strategy that identifies the real offender or a more likely one? Okay, so I see what you're saying there, and you're probably referring back to what I was talking about earlier in regard to not being that interested in a third party culprit. That's dangerous when defense goes down that line of going, okay, but it was this person. Firstly, that's not the defense's burden to do, so it's not up to them to go and find a third party. But also, it muddies the waters. So the defense already has a big job in its hand to refute all of the evidence that the state supposedly is putting forth, right? So Ann Taylor has said she's got 4 weeks worth of defense to put forth, right? So she has 4 weeks of rebuttal, basically. She's going to put forth expert witnesses that are going to testify. I'm sure there's going to be a lot of stuff about what is transferred DNA. Why is that sheath not important to you? There's going to be a lot of why does that cell tower data that you are showing, why is that not important? Because actually his phone was 40 miles to the west. There's going to be just a ton of refuting evidence to the stuff that the state's putting up there, and that is top level priority rather than bringing in a whole other set of facts. So I've seen it before. I've seen defense go and start bringing in a bunch of different possibilities, like, oh, but it was this person, and then also this person was involved, and there's this storyline that the jury has to take in, and it can work, but I feel like sometimes it can just, you could be cutting off your nose to spite your face. I don't know if Americans use that term. It can be counterintuitive. So in this instance, I feel like they just need to do what is their job, and that is disprove the state's case or rebut the state's case. So these motions here, what we're seeing, these motions to suppress, they're all what Kathy's saying. They're all fruit of the poisonous tree, Fourth Amendment violation. Absolutely, absolutely, yes. Hey, Laura Thomas. Oh, you're from Pings. Oh, hey, yes, you are. Nice to see you. Okay, so Kathy's saying, I hate to be negative, but I feel the jury will convict him if this goes to trial. No matter how weak the evidence is, his freedom hinges on these motions to suppress and the Franks motion, my opinion only. Kathy, you're speaking my language, and this is, I will continue to stream on this. I will continue to say this. You are 100% exactly saying what I've been saying and what I said on when Andrea came on here as well. And she actually said the exact same thing, that if this goes to trial, she didn't use the word screwed, I did. He's screwed. He's 100% screwed. There is no way that a jury will sit and listen and compute the 4 weeks of defense experts. She actually said that juries just look on experts as hired guns, and they don't listen. All they hear is they got his DNA on the knife sheath. That's it. That's all they're going to hear. And she even said, if they manage to suppress any of this other stuff, but not the DNA, they'll go to trial just with the DNA. They will. And they'll win. It's a sad, sorry state, but look what just happened to Rick Allen. You would think that there would be some sense, but no. It's just the way it works. You don't use that term. What does it mean? Cutting off your nose to spite your face is like, say you've got like like an ugly nose or a pimple on your nose. So you go, oh no, well, I need to cut my nose off, right? But then you look much worse without a nose, right? So, oh, you're in a mood. When are you not in a mood? Never say never, Casey Anthony. That was a long time ago. And that was Jose Baez. So I actually think that this defense team is up there with the likes of Jose Baez. He was an incredible theatrical lawyer. He really knew how to connect with a jury. I don't know, like Ann Taylor is exceptional, but I've not seen her in front of a jury yet. I've not seen her there yet, so I don't know. But look, here's the thing. I just want to get back to what Kathy's saying again. I'm pleased you said it, Kathy, because I wasn't sure if you're on the same page with me or not. But this can't go to trial. If he's the wrong guy, it can't go to trial. If he's the wrong guy, it shouldn't go to trial, right? And there's not enough evidence there right now. The judge knows, the judge is seeing everything behind the scenes. He should know whether or not there's enough there. And if he has the balls, he should pull the pin, right? He should suppress all this stuff, and therefore the state will have no choice but to pull out. Well, that said, the state will have no choice, because then over the top, the defense will come along with a motion to dismiss, and then he will have to have the balls to dismiss it. Now, that comes to my next question. Does he have the balls? Right? So that's why I wanted to talk about, can we predict, does he have the balls based on what we've seen so far? I am querying that, because whilst he seems to be tough on the surface, there's been a few things he's done that have made me feel like, I don't know. I think maybe he's just a little bit, his bark is worse than his bite, right? So let me show you what I mean. Okay, so let's go back to here. Okay, so we've seen Hippler greets the court. Now, he was very accommodating of the mitigation expert deadline extension. So that was on that very first day.
Experts.
Can you tell me if the one expert is a mitigation or a trial
You
expert?
probably can't hear that very well. Let me just go over to...
And what do you think you need for that mitigation expert in terms of a deadline?
Can you hear that or
That
not?
mitigation deadline was,
I believe it was March. I don't recall the exact date.
yeah, so that's a long time from now. So,
Do you need me to bring it into a new tab, or can you hear it
I'm
okay?
hesitant to ask you the questions because I'm sure you're not in a position to answer them currently, given the forum. So, but March is a long time from now.
Your Honor, the time passes very rapidly, and I appreciate the court not asking questions I can't.
He is soft-spoken, I know.
I think if I had an end of April deadline for that one witness, I think we could make that deadline.
Oops, sorry. There we go. Louder. Ooh, very loud. Okay, so what she's asking for is her mitigation expert has died, right? And a mitigation expert is incredibly important, because if he's found guilty, then there is the sentencing phase, and the mitigation expert has been on board right from the beginning, in order to basically fight for his life, right? And the mitigation expert has gotten to know him and his family, his background intimately. Mitigation expert dead. Need a new mitigation expert and need to get them across the case now. Right now, there is a deadline for that mitigation expert's reports and everything to be in. She's asking for an extension to that. And the state is probably like, great. But what can you do? They're dead. Right? So here is the judge on the very first day going, okay, so we're going to have to accommodate this.
So understanding this is a mitigation expert, Thompson, how concerned are you about getting that disclosure closer to trial?
Closer to trial is somewhat relative. The end of April sounds like it would be on the eve of trial from the date the court is proposing. I think that would be, I'm not sure that would be realistic. And again, I'm not in a position to second guess
Sure.
what Ms. Taylor and her team are representing to the court. She had told us some time back that one of her experts had some health issues, and I think that she did tell us that that person had passed away and they were working on a replacement.
Oh, I think she told us. Oh, yeah.
If we're looking at a mitigation disclosure at the end of April, I don't know that we could be ready with all the final trial preparation for a May trial. I hate to say that, I feel like I'm cutting my own throat in a sense, but that's realistic.
Well, I can do one of two things. I can set a separate hearing ex parte to explore this further, but I frankly don't know how far that's going to get me. I mean, I can set a date, and my experience tells me that date will be complied with regardless, right?
You'll get it done.
24 hours in a day, but if you use enough of those hours, enough days in a row, you get it done if you have to. At the same time, I don't want to put unrealistic deadlines. And so
See, this is interesting.
I can do that. I can have an ex parte hearing, or we can go ahead and reserve September. I will throw it to Mr. Thompson as what you want, what you would advocate for.
Yar, could I have just a
He
moment?
said he doesn't want to set unrealistic deadlines. I could just set a deadline, and my experience says people will just get
Yar,
it done.
we trust the court to do the ex parte hearing, see what's there, and make the best decision, and tell us what the expectations are.
Do you want to do that later today, or do you want to do it tomorrow?
Okay.
You need time? You want to come back next week?
Your Honor, I had planned to leave town today. I have other case-related obligations tomorrow. I could do it as soon as this hearing's over if the court has time, or I can come back next week.
Okay, so spoiler alert, he makes time that afternoon for her. So he's being pretty kind, I think. Like, he's like, okay, you got a dead mitigation expert. I'm not just going to set the deadline and make you just figure it out for yourself. I don't want to be unrealistic about it. He's asked the state, he's gone, would that be too long of a time for you, April? So that would be right on the eve of trial, considering that the trial at that point was going to be in May. It's not anymore, but at that point it was going to be in May, or May, June. And then he goes to her, because she's 7 hours away, goes to her, would you want to do it next week? Do you want to do it tomorrow? And she's like, I have to leave this afternoon. And he's like, he'll make time for her right now. Okay, great, sweet. So he actually, earlier he'd been, I don't want to be here, nah. And then he's actually been quite hospitable. Now, if we want to go to this next part, Hippler argues Logsdon's international law motion. Now, here we see him get a little bit fiery. So we've only really seen him in 2 hearings properly, all right? Now, this is the one where this has stirred up a lot of debate online, right? So the whole thing with the death penalty hearing on November 7th made people start to go, oh, well, he hates the defense. The defense is really stuffed up. I have thoughts on this. And this is why I got Steve Gosney on stream, because I really wanted to understand what happened with the death penalty motions. To me, I could tell that it wasn't a good look what happened at the death penalty motions hearing. And if, spoiler alert for those who don't know, there was an order from the judge after these hearings denying the striking of the death penalty. So the death penalty is still on the table for Bryan Kohberger. However, and in chat and later in the comments, people might fight me on this, but I'm of the opinion that the defense could have walked in naked and it wouldn't have made any difference. Okay, Kathy, see you, love. Message me later. I need to know that time for Saturday, for the stream on Saturday, because I've got a stream at 6 p.m. Cool. See you. Okay. So, yeah. Do I have a P.O. box? No. Yeah, I'm of the opinion that they could have walked in naked and they still would have had those motions struck down. And that's not by any mistake whatsoever, because those motions to strike the death penalty were not for right now. They were for the record. So when attorneys put motions down, they do not necessarily expect them to be sustained immediately. They sometimes put them down on the record for appeal, for the sake of the appellate court. And Steve Gosney spoke about that when he came onto my stream to talk about the death penalty motions. So if we look at this tab instead, if we look at these death penalty motions, here they all are. Those are the replies. But if we look at the motions to strike the death penalty, there's about 8 or 9 of them. Actually, there's more, there's 13. We have motion to strike felony murder aggravator, motions to strike HAC aggravator, that's heinous, atrocious, and cruel, multiple victims aggravator, motion to strike, motion to strike notice to seek, intent to seek the death penalty, international law, contemporary standards of decency, vagueness, failure to present aggravators, just this plain old motion to strike the death penalty. That one there is very interesting. Motion to strike utter disregard. There's so many of them. And then there were all the objections to them. And eventually there was a large memorandum / order from the judge saying no. Would naked court spur the interest in court proceedings? Maybe. Okay, so I can tell you right now that when Jay Logsdon, who wrote those motions under the guidance of Ann Taylor, when he wrote those motions, he was not writing them thinking that this judge was going to sustain them. It would be nice if he did, because he would have then created some case law that would affect other defendants as well. So he would have really had some balls if he did that. But wasn't really expecting him to. Yeah, not at this trial court level. But some of these arguments will definitely be at some point case law that's going to be applicable for Bryan Kohberger or a different defendant later down the track, and then that will in turn affect Bryan Kohberger if he is sentenced to death and he's sitting on death row. Somebody else is going to have their case overturned because of one of these. So, for example, more than likely the heinous, atrocious, and cruel death penalty aggravator. So, if you want to learn more about that, go and have a look at my stream with Steve Gosney, or even the very short version that I made, because we do cover that, the heinous, atrocious, and cruel one. Basically, it means that every potential premeditated murder could have the death penalty attached to it, because which one isn't heinous, atrocious, and cruel? But they all are. So therefore, it's arbitrary. Now, let's have a bit of a look at what happened that day. Hippler argues Logsdon's international law motion. Okay, so I think heinous, atrocious, and cruel comes into this one as well. Now, spoiler alert, Jay Logsdon turned up 2.5 hours late to this hearing. So you know how I was referring to turn up naked? Well, he turned up 2.5 hours late. So not a good look, but my opinion is I don't think it makes any difference at all. He still wasn't going to sustain any of these arguments. But it still was a terrible look. I'm not defending him for turning up late. Now I'm going to press play, but I'm also going to...
Situation. Whereas
Actually,
what I
can you hear
think
that
you're
okay?
arguing is that the Eighth Amendment must be read to be broader as to what international law would.
Hey, Mickey's headphones.
I think if what we're saying is that the state would argue that
Hey, Rachel.
we read the Eighth Amendment and that's what the international law must be, we're saying you have to read the international law to decide what the Eighth Amendment.
So you're having the international law dictate what the United States Constitution means.
Correct. And we are doing that on the basis of what the United States has said itself about the fact that they believe that they live up to these things, and the fact that we have, we discussed the charming Betsy canon, which is obviously a very old canon and typically is just about whether or not our statutes are in line with our treaties. But I think particularly in this case, where the United States has essentially said, you know, we signed on to this treaty because we live up by these same standards that everyone else does. We can look at what the international community thinks about those standards that we said we also abide by when we're determining whether or not we're living up to the standards in the Constitution. And
But what they said specifically is that we think that we are living up to those, even though we have and will enforce a death penalty.
and I think
Okay, hang on. Before we go on, two things. Firstly, yes, Kaylee, hi, how are you? Yeah, but didn't he more than likely get hung up in court for a different case? I doubt he just overslept. He actually said, I double booked myself today when he came in. And the court was actually quite fine about it. He was like, well, you're here now. And make your argument. So he didn't like go, oh, that's not good enough. So, but it was awkward. It was awkward because his name had come up a couple of times prior. So Eliza and Anne had to argue for him a few times prior, and unfortunately there were times when they did get caught out and they got asked questions about his motions. And like, for example, once the court asked, and what year was that case happened? And she was like, I know Mr. Logsdon knows that particular year, but I don't. And yeah, it was a bit icky for them. I felt really bad for them, but they recovered really well. So it was just one of those nasty kind of moments when he should have been there, but he got overbooked. So again, I feel like in the whole scope of everything, they knew that there was no way these motions were going to get sustained. So they had to have the motions on the record on that date, and they did. And they're very well written. So Steve, who I had on my channel, he is an absolute expert in death penalty law. And he read those motions and he was impressed. So there you go. Let's keep going. Oh, P.S. by the way, the argument he's making right now about international law and the Eighth Amendment, can you imagine it being sustained at trial court level? Think about it. So it's about decency, standards of decency, as the rest of the world sees the death penalty and the US, right? So can you imagine in a little Idaho court that being sustained? So, okay, let's just strike the death penalty because the rest of the world sees it as being barbaric. Okay. So, yeah, the chances of that are slim to nil. But maybe one day it could even be as soon as within the next sort of 6 to 10 years, the US Supreme Court might come round to that decision. And if that's the case, then whatever case that is the one that is the instigator for it, it will be on Bryan Kohberger's record as well. And if he's sitting on death row at that point in time, guess whose case gets overturned? Bryan Kohberger. So it needs to be on his record. See? Makes sense. But can you imagine this guy at this point in time making that record? Setting that case law? Oh, okay, sure. Yeah, I'm just going to say that US has got it wrong against the rest of the world right now in Ada County, Idaho. Yeah.
Which is why we're not saying necessarily that the death penalty would be struck if it was done properly. Our argument is that the way that Idaho has its scheme set up, there are far too many statutory aggravators, and some of them are just big enough to drive a Mack truck through. And so just about every murder could be charged and have the death penalty attached to it.
This is what we were talking about before.
That doesn't require the narrowing that we've said we're going to provide, and it certainly doesn't live up to what the international community would expect from us.
This bit.
Yeah, I understand the argument.
Well,
I'll be frank, it's falling about as flat as you would expect it to fall before our Supreme Court or the Supreme Court of the United States.
well, Your Honor, it's an argument, and it must be made, so
You need to make a record.
thank you, Judge.
Oh, felt it. It's an argument and it's falling about as flat as you would think it would in front of this court, the Supreme Court of Idaho, or the Supreme Court of the United States. Ouch. Ouch, girl. Yeah, okay. So maybe now, sure. But at some point, and it's not just, it's here's the thing, right? Other people are making this argument too. So there's like a bank of motions that other death penalty appellate lawyers and death penalty qualified trial lawyers are using with their clients at the same time. So like Steve was saying when he was on this stream, these guys wouldn't have just made all these motions up. They would be looking at what other lawyers are doing and putting them on the record for Bryan Kohberger as standard practice. Because if they don't, then Bryan Kohberger can claim that they are not doing their duty as effective counsel. So ineffective assistance of counsel. All right, so let's keep going. Now, this part I found particularly interesting. So Hippler shows his cards in the waiver of speedy trial argument. Now, if you're not aware of this argument, this was the one that was just titled Motion to Strike the Death Penalty. And when Steve came on here, he found this argument to be very interesting and compelling. However, you would need to be a judge with some serious balls on you to be sustaining this at trial court level. The argument is that you, as a defendant with the death penalty placed before you, have to choose between two constitutional rights. Right to a speedy trial and a right to have your counsel prepared for trial, because of the fact that as a death penalty defendant, you have this issue of mitigation, right? So if you're not aware of what mitigation is the sentencing phase, right? So you remember how we had the mitigation expert that died? Well, that means that that's a whole person who needs to be hired at the beginning of the case, and that person gets to know the defendant and their background and everything about them intimately in order to fight for their life, basically, when it comes to sentencing phase. And no matter what, if the state says that they're going to be going with the death penalty, at that point, a lot of extra work has to go in order to defend them properly against the death penalty. It turns into a whole different game once the death penalty is on the table. Maximum due process is required. So the person with the death penalty on the table, they suddenly have a longer period of lead up to their trial because there's a lot more work that needs to go in to that pre-trial process. That's also why the trial goes for longer, because there's that sentencing phase at the end, right? So speedy trial is in Idaho 6 months. Bryan Kohberger had to waive his right to a speedy trial because the work just wasn't done. There wasn't enough time to prepare his mitigation whilst getting all of the discovery from the state. We're still getting discovery, right? When I say we, the defense is still getting discovery from the state, and we're 2 years in. So it's very interesting to see how the judge here shows his hand a bit and makes it kind of clear how he just isn't willing to make this call at this level of court, right? So this is something that's for a higher court. Let's watch.
Mr. Kohberger faced in August of 2023 when he had to choose to continue his case, thereby giving up his speedy trial rights, or go to trial on October 2nd of 2023, 10 months after being charged with this case, with completely unprepared counsel. And that's really the crux of this argument. And the remedy is for the court to strike the death penalty because Mr. Kohberger had to choose between rights, reinstate Speedy, and reset a sooner trial date. That's the remedy. I want to talk about what happened and why Mr. Kohberger had to continue his case. The court's already heard a little bit today about the duties of counsel in a capital case and the kinds of investigations we must launch immediately. It's not just about the facts of the case, but it's also about the facts of the case. But the mitigation phase has to be launched whether or not you ever end up with a conviction. That work has to be done. That's the way it works, and it takes time to do that. You have to find experts, you have to find records, and it takes time to do those things as well. So, and discovery can be a really big deal, and I think the court is probably starting to understand just how big of a deal that is. Last August of 2023, when we were in that place where we had to make that decision, and there was a scheduling order from the prior court in this case that told us you have to continue it by this deadline, by this date, or you can't continue it and you're just going to go to trial. So I think we're positioned a little bit differently when we are truly in a place we have to give up one right to have another right. Had Mr. Kohberger gone to trial and stood on that right, his speedy trial right, and lost his right to effective assistance of counsel, there would have been more than a year's worth of discovery that his counsel would have not been able to know about. We have continued to get discovery. I think there's a bit more that continues to trickle in even past the deadline. I'm not arguing about that right now, but it's just a vast amount of information that Mr. Kohberger would have not had counsel prepared for.
Imagine that.
We do not have a mitigation investigation completed. We're in process with that still, a year and 2 months after that deadline. So he would not have
hang on.
had that
Wait.
to benefit him either.
P.S. I know this is an interesting argument, but notice in the background there, that's Mr. Logston walking in, right? So that's Jay Logston in the blue jacket walking in behind, right? So this was prior to Mr. Logston, before being called out. You can see, like, she's arguing his motion, which is a really good motion, by the way, this whole thing with the choice between the two constitutional rights. And he's walking in like, no one see me, behind her with his briefcase. And he's going to come around and sit in this seat next to Bryan Kohberger, right? So just notice that.
I think one of the most important things the court should think about when we think about Mr. Kohberger having to choose between his constitutional rights is that we're here right now because he couldn't get a fair jury in Latah County. And if we'd gone to trial in October of 2023, he would have maybe held on to his speedy trial rights. Well, he would have held on to his speedy trial rights, but he would have given up his right to effective assistance of counsel and his right to a fair and impartial jury.
What's wrong with the idea of Speedy evolving on a sort of good cause basis? I mean, capital cases at the time the Constitution was adopted were tried within 6 months, right? The standards of how to try those cases were obviously different. And as more contemporary thoughts about that have arisen, it's become the standard that they require more. And so why wouldn't Speedy be flexible to accommodate that?
Well, I don't know why it would or why it wouldn't, but that's not been what's happened. We don't have a separate criminal rule that says that. We don't have a separate statute that says that. We would bend the Idaho Constitution until it breaks to make it say that.
It's too late for that, Judge.
Kind of an example. During the time of COVID, when the Supreme Court told
this is a very good argument.
trial rights, it did that based on a national emergency. Court orders were issued. I am not saying whether I agree or disagree with that, but that's something that happened. And I think one of the cases the state cited in its response brief, State versus Ish, I think that particular case had 422 days of time between when the remitter was issued and when the case went to trial, and that person asserted their speedy trial rights that whole time. That happened during COVID, when the court had its emergency orders during that whole time. So I think to say, well, it's a capital case and they're a lot different than they used to be, and they are, and they're a lot of work and they take a lot of time and investment. They do. But there's nothing that's been changed in our Constitution, in a court rule, in a statute, to say if it's a capital case, speedy trial, really, you just don't have that right. A person facing the death penalty just doesn't have that right. All of those rights exist. They all exist right now. And Mr. Kohberger had to choose between those rights. And I think the court can and should strike the death penalty in this case based on the record.
That would
here.
result in the death penalty being struck in every case.
Ha!
Your Honor, if that's the way it is, because our clients collectively in the state of Idaho, when you have a capital client, if that's the case, then that's the case.
Yes.
I mean, we have been doing
The
this.
Constitution is flexible enough for the Supreme Court to itself say, well, we can pause that right.
Oh, so we'll give it to the
And we
Supreme
can
Court
expand
then,
that
why
right
don't you?
based upon the circumstances, i.e. COVID. Why can't it expand the time that Speedy is measured by constitutionally, given that evolving standards have required more time to present a capital case and measure it against that?
I would say that I don't know whether they can or they can't, but they have not. And that's the critical area. I would say the Supreme Court probably would believe it could do that, but it has not done it. And I would say they would believe that they could because they did so during COVID.
Ha.
But that hasn't happened. That
It
has
hasn't
not
happened.
So you
She's
think
so
that the
right.
Supreme Court would likely say, well, as opposed to interpreting the constitutional right more broadly to apply over the, be more flexible given how the defense of capital cases have evolved, they would be more likely to say, well, we're just going to not have any capital cases, period.
Sure.
I don't know
okay,
if they'd
let's do
say
that.
that or not.
Well, that's what
But
you're asking me to say.
I'm asking you to say that. I'm asking you to do
My job as a
what,
district judge, if there's not an issue that has been decided by the court, is determine how that court would decide things.
well, I think you can consider what Judge Boyce did in the
Ha.
Vallow case.
Yes.
And that had to do with discovery that counsel
Judge Boyce
didn't
made a
have
decision,
enough
sir.
time to review and to prepare for, and it would have disadvantaged the client. And so Judge Boyce in that case struck the death penalty.
That was as a result of the state having failed to provide the information, violating its court order. And then the remedies were, well, do we push trial back or not? And the choice that Judge Boyce gave the defendant was, well, we can go to trial, but I'll remove the death penalty because a lot of the discovery related to that. Or we can continue the trial for you to review that. But so you can either go to trial with the death penalty, without the death penalty now, or you can expand it with the death penalty. One defendant chose one and the other defendant chose the other. In this case, the decision to waive Speedy is not as a result of, as I understand it, a violation of a court order by the state.
It was as a result of a court order. And when we waived Speedy, we advised the court and counsel that this motion this day was coming. We don't think it's appropriate to force somebody to choose between competing constitutional rights. Lori Vallow had not ever waived Speedy trial. And so she had the choice to waive Speedy or not face the death penalty. And we think that since we were forced to choose between rights, those should be reinstated and the court should strike the death penalty.
Yep.
Thank you.
Damn good argument. And okay, so here's the thing, right? The judge just showed his hand big time, don't you think? He just said several times that that is an argument for the Supreme Court, that he wouldn't make that decision because then it would apply to all death penalty cases. Yeah, he'd be creating case law. So that takes balls, doesn't it, guys? Right, so this is what I'm saying about his bark being worse than his bite. I feel like he has all of these words. He sounds like he's this angry meaning, but when it comes down to actually being asked to make a decision that could be material, that could have some impact, no, I don't think he's going to. I don't think he's going to. And this is exactly what Gosney said. Yes, it is what Steve Gosney said. And I tell you what, like, I had a couple of people in my comments go, oh, I wish Steve knew the case more. Steve didn't need to know the case more. Steve's an expert on death penalty law and death penalty arguments and appellate law, right? He didn't need to. He had one glance at the list of motions, and when we started to read the motions, he could tell immediately what was coming up next, and he could say straight out that there was no way any of these things were going to be approved at trial court level. No way. No. Yeah. They're way above his pay grade, this guy. Way above. The motions are too broad reaching. They create too much of a precedent. So it would take a judge who really was willing to put his ass on the line to sustain something at this level that could have such ramifications. So it just, and he said it flat out. Now, here's the other thing. What does that mean for what's coming forward, right? So we have these motions to suppress, and they're a big deal, right? Now, the motions to suppress, I think he's going to play it safe, and he's going to actually allow them to play out. I actually think he's going to let them happen. He's going to let the state do their objections to them. He's going to allow the Franks hearing. He's going to let everything be argued, and it's going to be quite fair. And if it turns out that the state have done naughty and it can be proven, then there'll be a motion to dismiss. And I think we might see something along the lines of what we saw with Judge Summer in New Mexico. So if there's a motion to dismiss and it's proven that there were unlawful searches, there's enough of them, then yeah, I think it would have to be enough for him to not want to be overturned. But he doesn't have the balls, I think, to do something that is that could be questioned. Like, it has to be really substantial. Like, there has to be so much evidence there that he would be questioned heavily if he were to go with the state. I respect the judge for it. Too many people want to not stay in their lane. Journalists acting as pundits, politicians doing the same, judging wanting to be lawgivers. Yes, Mads. I don't think he has the balls to do something either good or bad. Look, this is what I'm trying to say, Miku's headphones. I don't think he's going to go out on a limb, right? I don't think he's going to do something that is like, oh my God, that's so out of the ordinary, right? However, I think if there's overwhelming evidence that the state has done something unlawful, then I think that he doesn't have the guts to not rule in the defense's favor. Do you see what I mean? Right? So I think he will just go with whatever is very clearly been proven. Right? And with the Franks hearing stuff, I believe that it has to be open to the public. Like, he can't not let us know what's going on with that. Also, just with the illegal searches, I mean, I know we don't know everything about it. A lot of it's under seal, but we do see the top level stuff. We do see what the orders are. We do see what the motions are. So, and that hearing on the 23rd, Andrea said that that one has to be open. That one has to be open. So when she came on here, she said it had to be open. So we're going to see a fair bit. I'm sure they'll go in camera for a bit of it. But we'll see a fair bit. So like, there's only so much they can hide. They can't hide everything. They're hiding exhibits, but they can't hide everything. They can't hide all the arguments. So I think he's a bit of a wolf in sheep's clothing. Oh, the other way around. A bit of a sheep in wolf's clothing. The dogs are barking dismissal. Look, here's the thing. I have thought this all along. I've been waiting and waiting for the dismissal of this case. I have said all along that this case is going to be dismissed before trial. And if it doesn't get dismissed before trial, he is going to prison. He's going to prison, probably the death row, more than likely, right? There is no way that Bryan Kohberger is going to trial and being acquitted. Don't care what county, don't care. He could be tried on Mars. But that would be it for him. So what about those snarky orders, right? So let's have a look at just one or two of them before we finish up. So because people have been up in arms about these orders that he's written and the tone that he's taken. Let's see. The thing about the naked, or is it? I keep saying naked, don't I? Is this the one with the naked? Ah, this is the naked one. Yes. Okay, so order denying motion for leave. So quite a few YouTubers and people have brought this one up and go, oh, look, he hates the defense. Before the court is defendant's naked motion for leave, in which he seeks relief from the discovery motions deadline of November 14, 2024, as set forth in the governing scheduling order. Defendant asserts his counsel and investigators are still reviewing the vast amounts of discovery in the case. In quotation marks, kind of like being sarcastic, and therefore he needs additional time to file motions related to discovery. Motions to enlarge a deadline filed on the eve of the deadline are not well taken. The state's discovery deadline was September 6, 2024. Defendant could have ascertained far sooner whether the discovery motions deadline would pose a difficulty and brought it to the court's attention. Further and importantly, defendant has not demonstrated with his filing good cause to enlarge the deadline. Ooh, you don't want to enlarge anything too much. He has not set forth what efforts have been made to review the discovery, what portion of discovery has not yet been reviewed, why it has not been reviewed, or how long it will take to complete such review. Consequently, his motion is denied in capital letters. Ordered and dated this 15th day of November 2024. Okay, so context is important, right? Context is really, really important, because here's the deal. The motion was submitted, as he said, on the eve of the deadline. So I think it was pretty sure that that motion was submitted by Jay Logston, the guy who turned up late. Oh dear. Naughty boy, Jay. Naughty boy. And this is the court flexing his muscle and going, if you're going to ask me for an extension, you need to ask me for an extension beforehand, right? And he's calling it the naked motion for leave because there is no explanation as to why you want a motion for leave. A motion for leave is for some extra time, right? So enlarging the deadline, motion for leave, it's just all like lawyer talk for, can I please have an extension, sir? Can I please have an extension? Right? So the court is just putting his grumpy pants on and going, no, you can't have it, denied, because Jay Lawson has gone and put in a request for an extension and he didn't write it very well and he wrote it too late. There's nothing wrong with this. This is not the court taking sides. This is the court like saying, I'm the boss and no, you can't have it. This doesn't mean anything. This is no big deal. I have literally seen live streams all about this document and how terrible it is for the defense and how did Ann Taylor and the defense team make the wrong choice in choosing to change venue, and is Hippler now going to be a thorn in the side of the defense because of that document, right? This is silly. This is just silly. Like, firstly, they didn't choose to change venue. That was something that they had to do. If they did not do it, that would be ineffective assistance of counsel, right? So they didn't choose to, they had to, right? It's better to be in Ada County no matter what. So having a trial in Lada County would have been, sorry to use a bad term, but it would have been suicide for Bryan Kohberger, because they would have found him guilty no matter what. Hey, Erica, how's it going? Enlarge a deadline must be a lawyerly misuse of language. Oh, yeah. They love saying enlarge. So here's the deal, right? So to take a document like this and to misconstrue it as being the court or Judge Hippler having some sort of bias towards the state purely because of this is just silly, right? The defense stuffed up. They big time stuffed up by asking for a deadline extension on the eve of a deadline and asking for it with no context. They were asking to have this reprimand, right? So what do you expect? This judges wouldn't have written something with this tone. Okay, he's a different guy. But if the state had done something similar, I'm sure they would have received a similar reprimand. Now, on that note, I am of the opinion that almost all judges have a state bias. The reason I think that is because in America, your judges are elected, and when they're elected by the people, and the people have a state bias. Why do they have a state bias? Because good luck being elected on a platform of let's be soft on crime. That doesn't make any sense, right? So the people trust the police, law enforcement, that kind of thing, prosecutors generally. So therefore, the judges tend to, well, they know that the people are going to like them more if they don't seem to be that loving towards the defense, right? So I tend to feel like judges have a little bit of a state bias generally, right? Whether or not that means that they are like chatting to the prosecutors, that's a different thing, right? So that would be a whole different kettle of fish. But what's this? Which of our LawTube lawyers said it's not good having former prosecutors become judges? Probably all of them. But how many of them are? Like, there's so many of them were former prosecutors. How many judges weren't former prosecutors? Do they all go that way generally? Judges also usually work in the same building with and work closely with the prosecutors, not so much with the defense. That's a problem. That I see as being a actual problem, because they end up like personally knowing them. So when you personally know somebody, you're more likely to have an affinity with them. They're your workmate. Even though you might not be talking to them about the case because you know that's wrong, like you know that's completely unethical to talk about the actual case, but you still know them. Like you still have some sort of rapport. So, yeah. Okay, so one other thing, just want to have a look at this other document here. So order re Frank's motion. So there is this Frank's motion, well, motion for Frank's hearing coming up. And there's been no response yet from the judge as to whether this Frank's hearing is going to go ahead. I think that the judge is not going to say anything about it until the state's deadline has passed. And is there anybody here from my group? Hello, Franks. Franks. Okay, so a Frank's motion or a Frank's hearing is all about investigating an accusation from the defense that the state or the law enforcement has unlawfully obtained a search warrant. So in this instance, because everything's under seal, we're not really sure exactly what that's all about. All we know is that there are a lot of search warrants. There's a lot of motions to suppress search warrants. So it could be a lot of things. The motion to suppress the IGG, as in the search warrant for his DNA, or his finding his DNA through his family tree, is important. But actually what I think it's about is the Elantra. So lying, the police officers lying in order to change the date of the Elantra search. So the search was for 2011 to 2013 Elantras, and then they changed it to be to include up to 2016 because they wanted his Elantra. Yeah. So you retrofit it because you have a particular Elantra in mind. Anyway, so just in regard to the wording or the way the court has worded his document, and this is in response to one of the defense's motions. So before the court is defendant's motion for Frank's hearing November 14, 2024, and memorandum in support of motion for Frank's hearing November 18. Accompanying the motion are 38 exhibits comprising over 2,000 pages. Unfortunately, defendant's memorandum largely fails to identify with particularity the relevant portions of the exhibits, instead referring simply to the exhibit number without identifying the precise pages at issue. Thus, the court is left with the unenviable task of sifting through pages and pages of largely irrelevant documents to ascertain what portion defendant may be referring to. The court is not required to search the record looking for evidence. Consequently, if defendant wants the motion to be considered, he must file a revised memorandum identifying the relevant portions of the record by page number and line number if referring to testimony. For the facts asserted, in addition, if defendant must resubmit his supporting exhibits to exclude portions that are not relevant to the motion because the state is under a deadline to respond. The court will allow defendant until Tuesday, November 26, 2024, to submit the revised filings. Okay, now people have made a really big deal of this too, right? The fact that he got grumpy, Judge Hippler got grumpy because he pointed out that defense has come along with this motion for Frank's hearing and hasn't been specific about what parts of the exhibits that he's supposed to look at. Well, what do you expect? Right? What do you expect? Do you really expect the judge to go looking through pages and pages? He's got 2,000 pages there are. Right? What are you doing, guys? Come on, lift your game. You were better than this. Right? Do you really think that the new judge is happy to go through 2,000 pages and work out what the hell you're talking about? Of course he's going to complain. So he's saying, pick your game up. But then again, he's also gone, this is important, and I'm going to give you more time. Because the state is under a deadline to respond, the court will allow defendant until Tuesday, November 26, 2024 to submit the revised filings. So he's gone, I'm pissed with you. This is annoying, but you can have till Tuesday to fix it. See? So he's a bit of a softie too, right? Yeah, normally a judge would put a cap on it too. Were the 2,000 pages watermarked? I don't know. See, here's the thing. I feel like people are kind of reading too much into his snarkiness. Because if you actually then look at what he says afterwards, he's then like, yeah, but okay. Okay. One more example. Okay, so before the court is the state's motion to strike defendant's memorandum in support of motion to suppress genetic information and memorandum in support of a Frank's hearing, blah, 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 blah. Right. So he's referring to the court, to the state's document. So the state's motion to strike defendant's memorandum in support of motion to suppress genetic information and memorandum in support of a Frank's hearing. So he's talking about the state now. He's talking about the state saying that the defense has stuffed up, right? So the state aptly points out that both memoranda violate Rule 8.1 and the 4th Judicial District local rules setting a 15-page limit on memoranda in support of non-dispositive motions. So states come along and gone, here, you've gone over limit. You've gone over limit on your documents, so you should strike them, judge. You should strike the defense because they've gone over limit, right? Defendant's memoranda at issue are 37 pages and 33 pages respectively. Moreover, defendant did not seek leave of court to file over-length memoranda, so they didn't ask permission to go over limit, right? Which is contemplated by local rule 8.3, right? So you can go over limit, but you've got to ask permission first. Given the breadth and significance of the two motions at issue, the court declines to strike the memoranda. Aha! See? Judge Hippler is like, yeah, I take your point, state, but nah. Yeah, nah. Had defendant moved for leave to file over-length briefs, it would have been granted. The court will, however, allow the state an equal number of pages in filing its response to the two motions. Hey, you want to write extra too? That's okay, you can. In the future, counsel shall abide by the page limits set by the local rules or seek leave of court in advance of filing an over-length brief. So he's basically said to the state, yeah, I see your point, but and in future you will have to stick to your page limits, but I'm going to accept what the defense did and state, if you want to write as many pages as them, that's fine. But yeah, nah. Yeah, nah. Yeah, he's saying don't be a petty bitch. That is exactly what he's saying, Caliph. Exactly what he's saying. Hey, need some teas. He likes to have rules and likes things done a certain way, and JJJ had no standards and no rules, it seems. JJJ was just, he was in over his head. I didn't mind him. I thought he was an okay guy. It was so much for him. He had never seen anything like it before. He was just sitting there and there were little birds flying around him. And he was just like, no. What do you want me to do? He actually said it a couple of times. What do you want me to do about it? Do you want me to sign these papers? Okay. He was so lost. And I feel with the change of venue, he could not do it fast enough. And he didn't even know how to do it. Like he handed it off to the Supreme Court, and he like copied and pasted a bit of legalese, some writing about how to recuse himself, basically. How to recuse himself without recusing himself. And yeah, it was kind of sad, really, the way he did it. But he needed to do it. He knew he needed to do it. And then he retired. He got the hell out of there. But I have no doubt in my mind that he had been planning that for a while. He knew it was coming. He knew that was coming. Because in January of 2024, so this year, in January 2024, there was the first change of venue, motion for change of venue, and he didn't go along with that one. And then just things got so much harder. Like, it snowballed so much. And I'm not sure exactly when in his mind he decided that he had to get out of it, but I feel like this case is what ended it for him. Like, he realized that he couldn't win. Like, this thing was so big. Yeah. I'm going bonkers because why write a motion? The judge chooses to accept it or not anyway. No need for a motion. What do you mean? Can we get little pocket hellers press her hand and say things like narcissist and not guilty? Oh, narcissist, not guilty. Oh, the motion to strike. See, it all needs to be on the record, right? So here's the deal. If with the motions to strike the death penalty, when I say that they knew full well that he was not going to sustain them, they knew full well and they didn't mind that he wasn't going to sustain them, right? Because they weren't aimed at him. He was not the audience for those motions to strike. The motions to strike, the audience for them was the appellate court, right? And maybe not even appellate court as far as Bryan going to the appellate court. Maybe somebody else with a different fact pattern, like Steve was saying, right? So maybe somebody else will have their cases overturned because of the HAC aggravator. Right? And if their case gets overturned because of the HAC aggravator, so will anybody else who has their motion to strike HAC aggravator on their record. So that's how it works. Right? So if they didn't have all those motions to strike on the record by the deadline, then that's ineffective assistance of counsel. So that's why it doesn't matter that Judge Hippler, Judge, whoever it was at trial court level, that's why it doesn't matter that he didn't strike the death penalty. He may still strike the death penalty because of other reasons. There's lots of discovery issues in this case. So you know how he was talking about how Lori Vallow had her death penalty struck because of discovery issues. Well, there's plenty of them here. So we still have that card. There's still that one, right? But yeah, it's very possible that could be the case. But absolutely, if you're interested in learning more about those motions to strike the death penalty, I really recommend that you go and have a look at that stream with Steve. I learned so much about death penalty law in that couple of hours I spent with him, and also by reading his latest book, which is Death Penalty Designs. Not being a lawyer myself and not being an American, not having much exposure to the death penalty and how it works, just watching death penalty cases play out in American trials, I never really understood, and I also have noticed that Americans aren't aware of what happens once the death penalty is put on the table. This whole mitigation process is such a big deal. Do you guys realize that when the death penalty is put on the table, like when the state seeks the death penalty, everything changes. So the entire process takes at least double the time, right? So you're looking at 2 years plus for a trial to start. If you don't have 2 years plus, then the defendant is absolutely not getting a fair trial. There's due process is not being followed, right? So this argument of the choosing between the two rights, the speedy trial right and the preparation for trial, being having a fair trial and having a counsel that is well prepared, that is a really strong argument. And at some point, either the Idaho Supreme Court or probably the US Supreme Court is going to sustain that argument. It will become case law, and there will be some sort of concession around the speedy trial period. So I don't know if it will be extended or there will be something done with death penalty cases so that the defendant doesn't have to choose between those two rights. It just sounds, it boggles my mind that this hasn't been already addressed. It doesn't make any sense. How can there be a speedy trial within 6 months, even 10 months, when you have this mitigation process which takes upwards of a year, 2 years? Doesn't make any sense. So, what's this, Erica? State overrides federal laws. Yes, we vote. Well, I can only speak for CA. Executions between 2017 and 2020 cost $1 million each. Yeah. And it's really so interesting to me because I see so many people who are so for the death penalty, yet they don't understand that it's not immediate, right? And they get really frustrated about that. And like Steve was saying, the quickest death penalty ever was 6 years, and that was because that person was begging for the death penalty. Like they were like, please hurry up, I want this to happen immediately, right? So that was 6 years. Okay, but that because of the way your constitution is set up, there needs to be maximum due process. There needs to be absolute assurity that all of the potential avenues for that person to have appeals have been gone through. So there's actually a mandatory appeal phase. So it's not like, is this person going to appeal? They have to appeal. Mandatory appeal. As soon as it's all over, there is an appeal. And those arguments that are put on the record, those motions to strike, that's for that mandatory appeal. So you got people like the victims' families, and there's only one family that has been speaking out very loudly right from the beginning of the 4 families, and they've just been wanting him to be in front of the firing squad right from the beginning as soon as possible. Well, sorry, but that's just not how it works. And why can't we get this thing to trial now? Why trial, 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 trial? Well, it's a death penalty case. If it weren't a death penalty case, the trial could have happened a lot quicker. Yeah, it's appealing. Then people say, why pay for him for the rest of his life? Well, because it's actually cheaper. Yeah, it is actually cheaper. Correct. That is actually true. It is cheaper. So I'm going to continue streaming on this. There's so much happening in the next month or two on this case. I can't even say to you how crucial these motions to suppress are. We could see Bryan Kohberger walking out those doors in the next 2 months. We really could. Now I know that, like I've said it. I said it the other day on Sean's stream that this could happen, and he's like, "Oh, don't get your hopes up." Blah, blah. I know it seems like a long shot, but if you've been following these motions to suppress and the search warrants and what's actually involved, it doesn't seem that far-fetched, honestly. The state they've been messing about a lot, and it's not even just these motions to suppress. There's more after that. So there's also a lot of misconduct that's been going on with the state. There's discovery violations that could follow on after. This Frank's hearing's going to be very interesting. So I think if he doesn't walk because of the motions to suppress, I think there'll be closer to trial. There'll be a Brady violation hearing. So he's cooked if he goes to trial. He's cooked if he goes to trial. That's absolutely true. I will say that. But if he doesn't, if one of these motions is successful, then he could be going home. He could be going home. All right, just having a look out there on the YouTubes right now. There's not much going on. No, okay, cool. All right, that's it. Look at me educating the public, are you? What are you educating people on? I feel like there's many reasons for the case to be thrown out, but unfortunately I don't have much hope for it. Look, I feel like you got to be Alec Baldwin. But then again, I feel like Ann Taylor is up there with Spiro. She's up there. She has been documenting everything so well. So well. Another reason to watch live streams, learn stuff from chatters. Yeah, you do. You do. And actually on that point, Half Irish, learn from everybody. I've been learning from lawyers since I started this, but I'm very careful to not limit myself to who I learn from. Take on board all of the knowledge I can from everybody I meet. So for example, Kathy in chat just now, she has her podcast, The Indie Zone. She knows the docket better than just about anybody. Her podcast, I think she got 350 or so episodes, each 5 minutes, and they're all about one of the documents on the docket there, searchable too. So absolutely, there are people who have been following this and are just wealth of knowledge from different perspectives. Like Diane, who was in chat before, she knows a lot about the actual housemates, the victims. She can tell you what they ate for breakfast the day before, for example. So there's just so much you can learn from different people if you look around. So like I said, like I'm not an expert on any one particular thing. I'm really more interested in what's happening with the court case than I am on any sort of alternate theories. But I think it's important to not get really stuck in your own mind and be like, okay, I know this stuff and I'm just going to talk about what I think and not take other people's views in. I also want to make it really clear that whilst I think he's not the right guy at the moment, I don't know everything, and I'm always open to being convinced of the opposite. So I'm not going to feel like anything bad's happened to me if he gets found guilty, and there's a lot of evidence to prove that. So, okay, it's happened before, that I've thought that perhaps, like with Sarah Boone, I thought that she potentially was more of a manslaughter case, until I saw all the evidence, and then I was like, nah, that's probably fair. Second degree murder is probably fair. So yeah, you're still going to gloat, Justin? You just like to gloat. You're like what we call a gloater. Can I come in for a gloat, they say? Oh, you heartless gloaters. Yeah. And that's okay, Mavka. See, being open to other people's opinions and being willing to change your mind sometimes as well it's really, really important. It's really important. Okay, that'll be it for me for today. I've talked for 2 hours and I've boomered and everything, so that was fun. Guys, Dali, are you going back to doing weight again tomorrow? Really? Really? No, I don't want your opinion. Oh, Ilya. Okay, that's it for me. Guys, have a great night. Great day. I'm going to go swelter in the heat and, like, maybe buy another one of these. Thanks, everybody. Time for the song. Time for the song.
Her name was Helen. She was an Aussie. She was a fake lawyer from the future. She got on YouTube and made some live streams. Her co-host is Darby and she dances sometimes. The words are always so loud because she's an 803.